Good afternoon, everybody, and for those of you joining us from across the Atlantic, good morning. Welcome to this Field Fisher webinar, Third-Party Cookies Are Dead, Long Live FLoCs. Just to introduce myself, my name is Phil Lee. I'm a partner in the Privacy, Security and Information team here at Field Fisher. And on today's webinar, I'm joined by my colleague, Thomas Birmingham, a secondee who is working with us at the moment. So I have been working in ad tech for a number of years now, and I think one of the symptoms of sort of working in that space is that you have to learn to deal with an awful lot of acronyms, whether that's things like SSPs, DSPs, DMPs, all those kinds of things. And to add to that long list, we now have a couple more to add to our vocabulary, which are FLoCs and the ATTF. Now, if you are joining this call and wondering what the FLoC we are talking about, don't worry, because we are going to explain that as we go on. Suffice to say, though, that FLoCs are Google's touted replacement for the third-party cookie. And over the course of the webinar today, we are going to take you through the sort of the potted history of cookies and cookie consent around the EU and the UK, some of the differences that exist between countries. We are going to look at some of the enforcement that is going on, where we think the regulation is going to go, and then how technology may be stepping ahead of where we are today. Now, as we go through the webinar, we are delighted to take questions. So you should see there is the opportunity to submit those through the webinar panel. Please do send them to us, and if we have time at the end, we will answer the questions that we are able. So without further ado, to move on, this is our agenda for today. We're going to, football is a game of two halves, and our webinar is really a presentation of three parts. We are going to look at the ePrivacy Directive. How has it evolved? How has it introduced these cookie rules? Where are we today? We're going to look at the ePrivacy regulation, which is the replacement for the ePrivacy Directive, and look at what the future may hold in terms of cookie regulation throughout the EU. And then we are going to ask the questions, will technology platforms ultimately prove to be the more effective regulators? And if you're wondering why we're asking that question, then stay with us. We will make that clear towards the end of the presentation. So let's begin by looking at the ePrivacy Directive and how did we get to where we are today. Now, just as a kind of summary of the rules, the ePrivacy Directive is the law in Europe, sometimes referred to as the cookie consent law, and it is the law that sets the requirement for consent when cookies are served on your computers. The rule comes from Article 5.3 of the ePrivacy Directive, and what it actually says is that you need to ask for users' consent to access or store any information on their internet-connected device. Now, one quick thing to note here is that it uses the terms access or store information. It doesn't actually use the term cookies. Cookies are one way of accessing or storing information on somebody's device, but they are not the only way of doing it. And so for those of you who are wondering whether other types of tracking technology are caught by this Article 5.3, whether that's digital fingerprinting or APIs, SDKs in mobile devices, then yes, all of those things will be caught by Article 5.3. So if you're accessing or storing information on a user's device, you need to ask for their consent. There are, however, two exceptions to that. The first exception is if the information you are accessing is necessary for the sole purpose of transmitting a communication. What would be an example of that? Well, imagine, for example, you're there at your computer, you're browsing the internet, and you visit a web page. Your browser needs to send your IP address to the website that you're visiting. And it needs to do that because the website needs to know where to return the content of the website to you. So your IP address can be gathered for that sole purpose of transmitting the communication to the website and back again. But if your IP address is going to be used for something else, let's say to serve you targeted advertising, then you might be back into consent territory. But that reason, this sole purpose exemption is the reason why you're not asked for consent by every website you go to access your IP address, because it's necessary for that sole purpose of transmitting a communication. The other exemption is where the access is or storage is strictly necessary to provide a service explicitly requested by the user. Now that tends to give rise to a lot of debate about what is strictly necessary. And the really important thing here is not to confuse strictly necessary with would be helpful if the website or the app could access this information. The way the regulators look at it, strictly necessary means that the website, the internet service would literally fall over if this information wasn't accessed. A good example of that would be a shopping cart cookie. So let's say you go to Amazon, you place something in your shopping cart. Now, your computer needs to remember what you've placed in your shopping cart as you continue to browse other pages, because you may add more into your cart. Now, in that case, you have clearly explicitly requested that item be added to your shopping cart. That information is stored on a cookie on your computer, and it's considered strictly necessary to enable you to remember the shopping cart items before you go to the checkout. So you don't ask people for consent in that context. But that is a very narrow exemption. Anything that is, for the purposes of targeted advertising, for example, would not be considered strictly necessary. And again, you would be back into needing consent. Now, if you do have to ask for consent, that consent must be to a GDPR standard. There's a bit in the ePrivacy Directive that says, by the way, consent has the meaning given in the old Data Protection Directive, and now the Data Protection Directive has been replaced by the GDPR. So consent is basically defined in the GDPR. And the GDPR says that the consent must be freely given, it must be specific, so you know who you're giving consent to, informed, and unambiguous. And that word unambiguous is generally taken to mean it must be opt-in, not opt-out. And in recent years, we've started to see some impactful case law. We've seen decisions like the CJ EU rulings in Fashion ID and Planet 49, a little bit more on them later. And we've started to see some fairly hefty DPA decisions as well, some big fines being handed down. And Thomas is going to talk about a little bit later on. But there's also some big changes afoot at an industry level too, with Google announcing that it is going to be phasing out third-party cookies in the Chrome browser, and Apple introducing the Apple AppTrackingTransparency framework, which we will move on to a little bit later as well. But just since we're completing this history tour, let's just look at how the law has changed over time. So the ePrivacy Directive was first introduced in 2002. And what it originally said was that if you were accessing or storing information using cookies, any of those kinds of things, you had to provide users with clear and comprehensive information, and you had to offer them the right to refuse. So over on the right-hand side, you'll see we've got the kind of keep calm and just say no. That was the kind of the mentality around it. And often what you saw was that websites from that kind of period would literally do nothing more than in their website privacy notice, they might just have one line that says, this website uses cookies. If you don't like it, change your browser settings. And that was how things worked up until 2009. Then what happened in 2009 was that the ePrivacy Directive was amended. And the key change that was made to the ePrivacy Directive was to change those words, the right to refuse, to say that the individual must give his or her consent. So here again, you've got the new language up on the screen. It says that if you're accessing or storing information, the user must be provided with clear and comprehensive information and give his or her consent, unless those exceptions apply. What did that mean in practice? Well, in practice, what you started to find was, to begin with, nobody did anything. There was a bit of delay. Nobody was really sure how to handle this. Then from around 2011 onwards, which was when the ePrivacy Directive actually had to be implemented into local countries' laws, you started to find that websites would put up banners that would say things like, by browsing this website, you agree to our use of cookies. And those were referred to as implied consent banners. But then you fast forward a few years and the GDPR came into effect, and the GDPR said consent had to be unambiguous. And so nowadays you start to see these unambiguous cookie consent banners, things that are much more comprehensive in terms of what they disclose and asking for sort of opt-in consent to cookies. So let me just walk you through that. So back in 2002, if we look at the evolution of websites over time, 2002, this was actually the Fieldfisher website back in 2002. Thank goodness for the Wayback Machine. I was able to find an archived copy of it. This is what the Fieldfisher website looked at back in that time. As you'll see, no cookie banner on our website at all. There was a legal disclaimer. Probably if you clicked on that, we might have said something about the fact that if you didn't like cookies, you could opt out by changing your browser settings. Then, as I say, we moved forward to 2009, and you started to see things like this. This was the Guardian's website. It said, this site uses cookies. This is actually from 2012. It says, this site uses cookies. By continuing to browse the site, you agree to our use of cookies. And what they did was they had a link saying, find out more here. If you clicked on that, you might be taken to a page that told you what cookies and maybe how you could turn them off. This was what people referred to as implied consent. By using the site, you were implied to consent to the use of cookies. But then we move forward a bit further and we get to the GDPR and its requirement for unambiguous consent. And now you start to see things like this on websites. You know, Hilson's example here is kind of one of the most comprehensive I've seen. You'll see it sets out different categories of cookies, required cookies, functional cookies, advertising cookies. You can click no or yes, depending on what you want. And if you click on the little view cookies link sort of underneath each of the different categories, it opens up this huge drop-down list of all the different cookies that Hilton serves. And by the particular provider of the cookie, you can opt in or out individually. A much more granular, much more comprehensive level of control. And these cookies are not being dropped until you indicate your preference, yes or no. Now, there have been some challenges with the ePrivacy Directive, with its implementation. To begin with, the ePrivacy Directive, unlike the GDPR, isn't a law that kind of automatically applies in all member states equally. Effectively, what the ePrivacy Directive was a law that instructed member states they had to pass their own laws that implemented its requirements. So member states around the EU had to pass their own national ePrivacy laws. And so what that resulted in was a patchwork of different local law standards across the EU and the UK. And the UK, of course, here was still in the EU at this point in time, which is why the ePrivacy Directive was implemented into UK law under the Privacy and Electronic Communications regulations. So that's complexity number one. You've got different standards around the EU. I've got a slide that will illustrate that in just a second. Complexity number two was that it was unclear exactly how the GDPR and the ePrivacy Directive are meant to fit together. And that's because they use slightly different language. So if you look at the ePrivacy Directive, it talks about consent for the access or storage of information. And subsequent regulatory guidance has made clear that that information doesn't have to be personal data. It doesn't have to be personal information. So if you ever hear people saying to you, well, we don't need to get consent for cookies because the data we collect isn't personal data, they're wrong. The ePrivacy Directive says you need consent for cookies, whether or not those cookies collect personal data. So that's the standard under the ePrivacy Directive. But under the GDPR, we also have this separate requirement that says if you are processing personal data, you have to have a lawful basis for that. And for those of you that are familiar with the GDPR, you will know that your lawful basis might be consent, but there are other non-consent-based lawful grounds for processing personal data too, like contractual necessity or like legitimate interests. So then there's a question that sort of arises, well, if we're collecting data by cookies, if we're relying on consent under the ePrivacy Directive to access and store the information, once we've accessed it, anything we then do with that data, can we rely on our legitimate interests? Or can we rely on something like contractual necessity? And truthfully, I think the jury is still out on that one. If you ask the regulatory community, they will probably tell you that ePrivacy consent under the ePrivacy Directive means consent under the GDPR, but there's nothing that very clearly indicates that as a matter of law. And so there's a lot of confusion around that point. And you will still find, particularly if you're in the ad tech space, there are a lot of ad tech vendors that will still say that, well, the website needs to get consent to drop their cookies in the first place, but once data is passed to them, they then rely on legitimate interest for any kind of profiling and targeting that they do. And just to illustrate those kind of patchwork standards around the EU and the UK, up on screen here, you will see for some of the issues that are presented by cookie consent, you'll see the different standards, the different regulatory guidance that's been produced in the various countries. So for example, if you take, well, maybe let's start with the easiest thing. You know, all countries essentially agree on the fact that you have to identify third parties who are dropping cookies within your cookie banner, within your cookie policy. So it's kind of universal agreement on that. You actually have to say you have cookies being dropped by, you know, Google or Facebook or Amazon or whoever it is that's dropping the cookies. Secondly, they all agree that there should be a requirement for granular consent. In other words, you should be able to choose by the provider of the cookie whether or not you want that specific provider to drop cookies on your device. So there's kind of broad agreement on those points. But that is where the agreement, the kind of consensus seems to end. If you look at whether or not it is acceptable to use implied consent by browsing, in most countries the answer is no, but there's still some guidance hanging about in Italy that seems to suggest that implied consent would be acceptable. Similarly, if you look at the ever difficult question of analytics cookies, you know, there are some countries that take the view that analytics cookies fall within the strictly necessary exemption. They see it as kind of strictly necessary that you set an analytics cookie to work out, you know, which users are visiting your website, and because that information may be useful for capacity planning or whatever of the site. Or maybe they just don't consider it enough of a risk to warrant consent. But then in any event, you will see there are countries like France, Italy, and the Netherlands that actually allow exemptions for consent for analytics cookies. But most other EU countries, you know, Germany, Spain, Greece, Denmark, and yes, the UK, not being part of the EU anymore, all consider that you do need consent for analytics cookies. So very difficult to implement a one-size-fits-all solution across the EU. And then when you get onto the issue of cookie walls, it gets potentially a little bit more complicated still. What do we mean by cookie walls? What we are talking about are those kind of things that when you go to a website, they present you with the ability to consent or refuse cookies, but they don't let you into the website unless you make a choice, or in some cases, unless you actually agree to cookies. And you know, in most of the countries around the EU, you'll see the answer is no, you can't force people to agree to cookies in order to access the website. Spain has some guidance that seems to indicate yes, you might be able to, and the UK, you know, in good British standards, has sort of said that it's unlikely that cookie walls will be valid. But again, you know, there's not a rip-roaring consensus across all of the different authorities and in the guidance that they've issued to date. So that's where the law stands at present. Now, one of the really interesting things about this is that enforcement of cookie rules has historically been relatively limited. But what I'm going to do now is just hand over to Thomas, who's going to talk to you a little bit about how we're starting to see that change. So Thomas, over to you.
Great, thank you very much, Phil. As we can see, looking at the timeline on the slide, historically there have been very few fines under the ePrivacy Directive. So you can see from 2019 onwards, outside of a few high-profile cases involving the CNIL in France in January 2019 and culminating in the substantial headline fines to Google and Amazon in late 2020, there isn't generally a trend towards sanctions being imposed as a result of ePrivacy Directive infringements. And as you can see, the CNIL is very much an outlier for sanctions of this nature. For instance, the Irish DPC and the UK ICO have yet to register a fine under the ePrivacy Directive. In the event that sanctions are imposed, they tend to be considerably lower than the sums you're used to seeing levied under the GDPR regime. Fines by the Spanish DPA generally don't exceed the €30,000 mark. We can see that with respect to Vueling, which is €18,000, and Twitter, which hit the €30,000 threshold. And in the case of the Belgian DPA, the fine to the legal website jubel.be didn't exceed the €15,000 mark. So this can be starkly contrasted with the fines levied by the CNIL, which exceed €185 million. It's worth noting that the €50 million fine you can see in January 2019 was brought in relation to GDPR and had a tracking and an ad personalization element. So this 2019 case can be contrasted with the later cases for Google and Amazon in December 2020, which were ePrivacy specific in nature. So moving on to the Amazon and Google cases themselves on the next slide. So looking at these cases, broadly speaking, the issues that have been raised in relation to cookie usage by the two entities were on three grounds, two of which were common to both Google and Amazon, namely the transparency issue, the lack of prior information given to end users about cookies, and secondly, a lack of prior consent for advertising cookies. The third issue, in the CNIL's opinion, surrounding a defective opt-out mechanism or ability to object to cookies, was specific to Google. Next slide, please. So looking at the specifics of each of these cases, Google was subject to an aggregated fine of €100 million, of which Google LLC was subject to €60 million and Google Ireland Limited was subject to €40 million. So the CNIL had levelled these fines based on the following grounds. So in regards to transparency, in the view of the CNIL, Google had failed to inform Google search users about the existence of Google cookies on google.fr, what their purpose were, and how users could refuse them. So the banner displayed on the website only mentioned that further information was accessible on another page entitled Confidentiality Rules without explicitly referring to cookies. So the information relating to cookies was very difficult to access, as users had to scroll down the confidentiality rules to click on another options button. So secondly, on the issue of consent, during the online inspections, it was found that as soon as users started browsing Google, 7 cookies were automatically set on the user's device. So 4 of these cookies were advertising in nature. And with respect to the ability to object or opt out, when a user had deactivated the ad personalization by turning off the personalized ad features on Google search by using the mechanism from the Access Now button, one of the advertising cookies was still stored on the user's device and kept reading information destined for the server to which the cookie was attached. It's worth noting that during the course of these proceedings, Google had modified its banner to be more explicit and the use of cookies and their purposes, and we can see an example of this in the on the slide itself. Next slide, please. So moving on to the Amazon case, Amazon Europe fined 35 million euros. So on the transparency issue, the CNIL felt that Amazon had provided either incomplete information about cookies or in some cases no information at all. So in that regard, the CNIL considered that the cookie used for the purpose of offering and improving our services, as Amazon set out, did not make users aware of the cookies that were used for targeted ads. The ad choice icon displayed on ads was also deemed insufficient. In addition, the banner used on Amazon's website did not inform users about how they could reject cookies. Lastly, it was felt that a cookie hyperlink inserted at the bottom of the web page did not amount to enough information. So on the consent side, when users visited the site or visited the site having clicked on an ad published on another website, more than 40 advertising cookies were automatically set on their device. More specifically for Amazon, Amazon's cookie banner inferred consent from further browsing, which the CNIL confirmed did not amount to obtaining prior consent. And again, similar to Google, Amazon also has clearly now updated its cookie banner to be more clear to end users about their use of cookies. And now I will hand it back over to Phil to discuss some case law from the Court of Justice of the European Union.
Thanks very much, Thomas. And actually, just while you were speaking, Thomas, I can see we had one question that came in, or sorry, rather a comment, I should say, noting that the Data Protection Authority in Norway uses Google Analytics cookies on its website without consent, and so it is perhaps safe to assume that you can use analytics cookies in Norway without consent as well. I would say that's a fair observation, although it's also interesting to note that within the past few months, I know the European Court of Justice got into some trouble for using cookies on its website without consent. And this is the same CJEU who issued the rulings in the cases that I'm now going to speak about. So sometimes there's a little bit of do what I say, but not necessarily what I do. So let's look at that Court of European Justice case law. So we have two of the sort of the impactful cases up on screen here right now. The first of these was the fashion ID case. And in essence, what happened here was that you had a fashion retailer running a website that was using Facebook like buttons on the site. And when you landed there, it meant that some of that data, when somebody loaded the website, it loaded the Facebook like button. It meant that some of that data was being collected and transmitted to Facebook automatically from the website. And the court ultimately ended up ruling in that case that there was a complaint from a German consumer association, and the court ultimately ended up ruling that actually the website and any kind of third party that it was allowing to place trackers through the website had to be considered joint controllers, and therefore there needed to be joint controller terms between the website and the third party, at least for the initial collection of the data. What the third party, Facebook in this case, subsequently did with the data, it did as an independent controller. So it's starting to get quite complicated here, because you're saying joint controllers when the data is collected, but independent controllers depending on what happens with the data subsequently. And they also said that the website operators needed to inform users when they land on the website and get their consent before dropping any third-party trackers on them. So that's quite an important point, really reaffirming the point that you have to inform people and get their consent before cookies or similar tracking technologies are being placed. Importantly, although this case was actually heard and the ruling was made in 2018, it actually related to a pre-GDPR case. So this was even before the GDPR introduced that requirement of unambiguous consent. The court was really saying even before then, there was a requirement to get this kind of opt-in consent standard for any cookies and trackers that were being used. That was then sort of closely followed just a few months later by the Planet 49 case. And what happened here was that you had an online promotion that was being operated. And within the online promotion, there was a pre-checked box where it confirmed that anybody who was entering the promotion consented to the use of cookies, but importantly, it was pre-ticked. And the court basically said that pre-ticking the boxes was not a valid way to obtain consent. And again, there must be some kind of affirmative action by the user to give consent to the use of cookies. And they also clarified a couple of other points, saying that this requirement for consent for cookies applies regardless of whether or not personal data is processed, to the point I made earlier on in the slides. And they also made the point that cookie notices must also disclose the duration of the cookies that are being set and the identities of the third parties that are setting them. And as a matter of market practice nowadays, I'd say it's quite common or increasingly common to see companies disclose the third parties that are setting the cookies, but it's still pretty rare to see anybody actually disclose the duration of cookies. So if that's something your own cookie policies don't do currently, it may be something you want to think about revisiting. So that kind of takes us through a sweep of 2002 to the present day, if you like. What we're going to do now in this next part of our presentation is just look at what does the future hold. So we're looking here at the ePrivacy regulation. What is the ePrivacy regulation? Well, in very simple terms, you can think of the ePrivacy regulation being to the ePrivacy Directive what the GDPR was to the old Data Protection Directive. It's the kind of successor legislation for the ePrivacy Directive. And in the way that the GDPR was intended to kind of reform the Data Protection Directive and bring data protection standards up to the kind of the 21st century, that essentially is what the ePrivacy regulation is intending to do to the ePrivacy Directive. It's meant to introduce greater harmonization. Being a regulation, it would apply equally in all member states around the EU, rather than having this patchwork quilt of different member state laws that you have currently. It would introduce stricter penalties for infringements. And again, it would aim to be a bit more modern, a bit more up to date, and deal with some of the risks that are presented in sort of modern day online data processing better than the current ePrivacy Directive does. That's the theory, at least. And just one important point to note, because the UK is no longer part of the EU, the ePrivacy regulation, when it is passed, will not automatically apply to the UK, although companies in the UK who have customers in the EU may still need to comply with it by virtue of that. Now, in terms of where we are, the original draft of the ePrivacy regulation was put into play by the European Commission in January 2017. Now, the actual original objective was that the GDPR and the ePrivacy regulation would come into effect at the same time. So the goal of the Commission was to have the ePrivacy regulation kind of swiftly adopted, maybe in the space of a year, and then, in May in 2018, the GDPR and the ePrivacy regulation would come into effect at the same time and work hand in glove. The fact that we're here having this webinar kind of can tell you that that didn't happen. The ePrivacy regulation is still being debated by the legislator over 4 years later. The position we are at currently is that we have sort of 3 different drafts of the ePrivacy regulation in play, if you like. And to understand why we have 3 different drafts, it helps just to understand how European Union law is made. In very simple terms, what happens is that the European Commission initially proposes a draft law, and then what happens is that draft is sent to the Council of the EU and also to the European Parliament. And you can kind of think of them as, in very loose terms, as being like sort of upper legislative and lower legislative chambers, a bit like sort of the House of Lords and the Parliament in the UK. And what happens is that the Council and the Parliament each go away in separate committee meetings, and they each inspect the draft and they consider what changes they think ought to be made to it. And then they kind of agree what they call their negotiating mandate, which is the version of the draft as they like it, the version they're adopting. And then they come back together in this thing called the trilogue, which is essentially a three-way negotiation or a two-way negotiation brokered by the Commission. So what we have at the moment is that the Parliament actually agreed its negotiating position all the way back in October 2017. So it kind of moved relatively quickly. The Council, though, has taken a long time to get an agreement on the position it wants to negotiate, and it only succeeded in achieving that in February 2021. So now we are at the stage where the Council and the Parliament will negotiate the ePrivacy regulation together, with that negotiation brokered by the Commission. And you can kind of see just on the right-hand side of the screen here, I've put up just a kind of a diagram from the EU's website indicating what the trilogue process looks like. But essentially, you can see it's a bit of sort of negotiating argy-bargy, going backwards and forwards through different levels of reporting. Ultimately, what happens, you hope, is that the trilogue concludes in a provisional agreement between the Parliament and the Council, and then both the Parliament and the Council go back to plenary sessions to vote on adopting the agreed draft, and then it becomes law. How long does that process take? Well, it's really a question of how long is a piece of string. It took a couple of years with the GDPR, so we may still be discussing this for some time to come yet. Just if you're interested, that is what a trilogue meeting looks like. That actually is a picture of a trilogue taken from 2017 up on the EU's website. But probably the most interesting thing to understand is, what is the ePrivacy regulation likely to do when it comes to regulating cookies and other types of trackers? Well, there's kind of good and bad news depending on how you look at it. The bad news for those of you who are hoping that we'd be doing away with cookie banners all around the EU is that they are here to stay. The consent for cookies and similar trackers is not going to go away. It is in the draft that the Commission put out, and you can see from this table up here that both the Parliament and the Council agree that consent should be needed for cookies. There was some debate about whether we should do away with consent and maybe allow legitimate interest, but that seems to have kind of withered on the vine. So everybody agrees consent is going to be needed for cookies unless they are exempt. The good news, though, is that there is recognition that there needs to be some broadening of the categories of cookies that are exempt from the consent requirement. And so up on the screen here, again, we've listed out the categories of exemption that are under consideration. Now, in its original proposal, the Commission really just kind of included one extra exemption. So we already had exemption where, necessary for the sole purpose of transmission, and we already had exemption for where strictly necessary for the provision of user requested services. Those remained in the Commission draft. Parliament and the Council agree with that. But the Commission also included a new exemption for analytics. So if you think back to that slide a little bit earlier where there was a bit of a patchwork quilt around the EU as to whether or not you needed consent for analytics, the Commission is proposing that analytics, or as it calls it, web audience measurement, would be exempt from the requirement for consent. Parliament and the Council broadly agree with that. They've got some conditions around it in terms of, how, the fact that there's clear transparency about analytics, that maybe there's the ability to opt out, that if you're using a third party to collect the analytics for you, that you have a data processing agreement with them. So they add some conditions to it, but ultimately they agree that analytics should be exempted from the consent requirement. So some good news in that the ePrivacy regulation, whenever it is adopted, is likely to exempt analytics. Then beyond that, the Parliament proposed an additional exemption, which was that there ought to be an allowance to collect data, which is necessary for sort of security software updating purposes. A slightly peculiar consequence of the current ePrivacy directive is that automatic software updates to computers are potentially illegal, because, or at least they're illegal if they're done without consent. Because if you think about it, to download a software patch onto somebody's computer, you're storing information on their device. Is it for the sole purpose of a transmission? No. Is it strictly necessary to provide access to the service? Debatable, but it's not entirely clear. But so the Parliament was proposing a new exemption that ought to say security software updates ought to be exempt, subject again to certain conditions, that it really is necessary for security and so on. And both the Parliament and Council broadly agree on that. So it looks like security software updates will also be exempted. Council goes a little bit wider and also talks about maybe collection of information for anti-fraud purposes and so on. Then the Council also proposed another exemption where basically to locate devices in emergency circumstances. So if you think, maybe you're out hiking in the wilds and you fall over, break a leg, you need an ambulance to come and get you, you dial 112 on your device. Well, that's great, but then trying to describe where you are to a call operator may be difficult. What would be a lot easier would be if that operator could just access the location of your device. And so the Council is proposing that. Sounds very sensible, so hard to see why it wouldn't be approved. And then the Council also, and this is a slightly more controversial one, proposed that there ought to be an exemption from consent if you're using data for different purposes for the purposes you originally collected it for, but those purposes are compatible. And what they are with the purposes you originally collected. And what they're trying to do there is mirror a similar exemption that exists under the GDPR. That one I can imagine there'll be a little bit more fighting over, but the Council have proposed that. And then finally, just to note another interesting point, the Parliament have explicitly added language into their draft of the ePrivacy regulation around whether or not a service provider should be able to refuse access to their service if the user refuses to give consent. So again, if you think about this in an ad tech context, let's say you're a free fund, you're an ad-funded service. You're otherwise kind of free, but your access to your service depends on collecting data and serving people ads based on their data. Well, the Parliament is saying, no, you cannot refuse access to a service if consent is refused. It has to be a completely free choice. And if somebody refuses, you still have to allow them to access your service. Both the Council and the Commission drafts are silent on that point. So we'll have to wait and see what happens. But what you can see here is that there's some difference between the parties, some things that look like they're very clearly going to make it into the final draft, others that are probably going to attract a little bit more debate. So that's it for the ePrivacy regulation. It's in progress. We don't fully know when it will happen. The trilogue negotiations began about a week ago, so they've probably got some time to go. It seems unlikely that we'll see the ePrivacy regulation come into effect this year. It's probably more likely next year if it happens. But in the meantime, industry has continued to forge ahead with its own developments. And I think this starts to raise the interesting question about, who proves the more effective regulator, not who platforms prove the more effective regulator. It's will platforms prove the more effective regulators? Why are we asking that question? Well, let's look up on the slide here. Very recently, the poor old Irish Data Protection Commission has come in for some criticism over its non-completion of investigations that it has commenced. Since the GDPR, it has been inundated with complaints. It has opened a number of investigations, but to date, sort of 90% plus of those investigations have yet to conclude, despite us being over 3 years now into the GDPR being into effect. And so civil liberties campaigners like None of Your Business, you've got Max Schrems up there, like Dr. Johnny Ryan over in Ireland, are starting to ask the question, are the regulators up to the job? And, unfortunately, I think you have to feel sorry for them because a lot of these regulators are severely under-resourced, and some of the investigations they are conducting are incredibly sophisticated. And so, these things do take time to investigate, analyze properly, and try to come down with not just knee-jerk responses to things, but actually considered opinions that make sense, that protect people's rights, but also don't completely shut off sensible uses of data. Meanwhile, you've started to see industry take things into its own hands, particularly sort of Google and Apple more recently. I've got up on the screen here, you will see a report about Apple's new operating system update for iPhones, iOS 14.5, and what that did was to introduce this thing called the AppTrackingTransparency framework. And in effect, what that does is to require apps that want to track you to ask for your opt-in consent. And the early reports have been that in the US, 96% of users have declined to give that consent. They've opted out of tracking. So on the one hand, you've got the regulators who are struggling to enforce these ePrivacy rules. On the other hand, Apple, through a simple change to its operating system, has basically shut down seemingly 96% of tracking that's going on. So, one fell swoop has had far more effect on tracking than the regulators have had to date. Now, depending on your perspective, that's either a very good thing or a bad thing. If you're a civil liberties campaigner, you're saying, great, you know, Apple have really shut down the data brokering industry. If you are an app that depends on targeted advertising as your lifeblood to fund the advertising that you do, and the apps that you provide, to fund the apps and the services that you provide, then this is a bit of a disaster, because a lot of your revenue stream is then going to be cut off. But let's look at this in a little bit more detail. To begin with, sort of understanding how these things are changing, it helps to understand how things work today. So let's just take a very simple example here. So at the moment, here I am, I'm in front of my computer, and I visit a website, and that website has partnered with various different ad tech vendors in the background. Now, what happens when I visit that website is the website will drop a cookie on me, or the partners of that website, the ad tech partners, will drop a cookie on me. You know, first they check to see if they've already set one. If they have, they'll look at that cookie. If they haven't, they'll set a new cookie on me, and that cookie will have a unique identifier. Let's say it gives me a cookie ID 12345. Now, the next time I browse to a website, or you know, that's using those same ad tech vendors, they can read that cookie. They can say, "Oh, we saw Phil previously. You know, his cookie ID 12345. So we know we've seen cookie ID 12345 on a different website," and they can start to use that information to build up a profile of the different websites that I'm going to, and they can use the information about the websites that I'm visiting to start to discern what my interests are likely to be, and then to target adverts to me. So, you know, if it was me, they would probably notice that I visit legal websites and technology websites, you know, and movie websites. And they say, oh, this is a guy who's interested in technology and gadgets and movies. So we'll show him adverts about the latest things that are coming out at the cinema, or that are streaming on Netflix, or whatever it happens to be. And that's how it works. But they build up quite a detailed history of you know, the sites that I'm visiting. Now, important thing to note here is they don't necessarily know that it's Phil Lee who's browsing around. All they know is it's cookie ID 12345. So they know an identifier, but not specifically that it's me. But they will have a lot of rich data associated with that identifier. And they use that to serve ads that are relevant to my interests. Now, there's been a lot of controversy about third-party cookies, a lot of concerns about, you know, about the fact that this is just one privacy invasion too far. And so in an attempt to respond to that, what Google has now announced back in the start of 2020 was that it was going to phase out the use of third-party cookies in its Chrome browser. In other words, if you visit a website, that website can drop a cookie on you because it's not unexpected. You're going to that website, you expect it maybe to gather some information about you. But any third party sitting behind that website, all the advertising vendors, you know, you don't expect them to track you. You don't know they're there. Their tracking is largely invisible to you. And so Google is saying that it is phasing out all of those third party cookies, and is aiming to do that by 2022. And this is highly significant news, because Google Chrome has 2/3 of the browser market share as of April 2021. And when you take into account that other browsers like Safari and Firefox and Brave are also blocking third-party cookies by default, actually, this looks like it's not just a Google initiative, but like you're really spelling the end of third-party cookies and third-party advertising on the internet. But then you start to ask yourself, well, hang on a second, is this really going to, you know, is Google, that has built its industry, you know, its business up off the back of, you know, collecting data and using it for advertising purposes, is it really going to spell the end of third-party advertising? Well, the short answer to that is no. Google is trying to find the middle ground in terms of enabling targeted advertising to happen, but in a way that is more privacy respectful. And so what it has proposed is this thing called the federated learning of cohorts, or FLoC. And if you're wondering, you know, why it's called that, there are essentially two reasons. One, federated learning is a form of artificial intelligence. It's a form of machine learning that takes place on user devices. It's also abbreviated to FLoC because Google has a series of privacy initiatives for its Chrome browser that it refers to as a privacy sandbox. And each of those different initiatives, it has given it, you know, it is named after some bird-related theme. One of them is called turtle dove, and so this is like a flock of birds. Anyway, that's the background to it. The way that FLoCs work is that instead of when you visit a website, that website dropping a cookie on you with an ID that is specific to you and collecting data about your browsing history, what instead happens is that the Google browser will instead group users who have similar browsing interests into what it calls a cohort, so a kind of group of users who display similar types of browsing behavior. And there'll be a minimum of at least 2,000 users in each cohort, which makes it very difficult to identify any one person within a cohort. And then each cohort, each group, is going to be assigned a cohort ID. And Google is just literally giving it a label, a sort of a number, an identifier, but it's not assigning any interest labels to the cohort. So it's not like there's going to be a group that says, this group is interested in movies, this group is interested in sport. It will just have a number. And then what will happen is that websites and ad tech vendors will be able to access that cohort ID, the group ID. And that's meaning that they can then start to work out what the group might be interested in and target ads to anybody who happens to be within that group. But they won't know at an individual level what that one individual, all the different websites that one individual is visiting. So let's look at how this works. So let's say we've got 6 different browsers here. So we've got browser 1, the user predominantly visits film review sites. Browser 2 is visiting football sites. Browser 3 goes to video streaming sites. Browser 4 is going to biking sites. 5 is going to tennis related sites. And 6 is going to video gaming sites. Now, what will happen is that the Chrome browser using sort of AI will basically start to say, well, okay, we're going to create these groups of users. We think, browser 1, 3, and 6, they display similar profiles, possibly because they all appear to be interested in sort of entertainment-related activities, or digital entertainment activities, whereas cohort 2, they appear to be more sort of sports-related interests, so we're going to group browsers 2, 4, and 5 into cohort 2. And then what it does, it assigns the cohorts an ID. So cohort 1 has the ID 43A7, cohort 2, 56B9. And that's all the information that will be available to the websites and to the browsers. So now, when I'm browsing around, I visit a website, and the website requests the cohort ID from the browser, and the browser then sends back to the website or the ad tech partner cohort ID 43A7. And so the ad tech vendor doesn't know specifically that it's me. All it knows is that there's this group of users who've been assigned the ID 43A7. And what it will then try to do is work out what that cohort is likely to be interested in. And let's say the ad tech vendor has partnered with let's say a sports website. Actually, let's say an entertainment site, because that was what we were using 43A7. Let's say it's partnered with an entertainment website, and it knows that somebody in cohort ID 43A7 is visiting an entertainment website. So probably that's a cohort relating to entertainment-related activities, and so it'll maybe serve a targeted ad relating to digital entertainment. But again, it doesn't know specifically the individual's ID. It only knows that there's this group of users and that the browser currently visiting that site happens to be within that group of at least 2,000 users. What are some of the residual risks with this? Well, FLoCs don't solve everything. If you're collecting other information with the cohort ID, maybe IP addresses, maybe other device information about screen resolution or or operating systems or things like that, maybe you can use that information collectively still to create a digital fingerprint of the individual to track them around the web. So there is still some risk there. Similarly, if it's a website that you log into and you as the website owner happen to know somebody's, say, email address as they log in, you can then match that with their cohort ID. And so again, perhaps you can start to use that to track them by associating their login details with the cohort ID. And there's also the risk that, what if Google Chrome starts to create sensitive cohorts, maybe starts to recognize that certain cohorts are visiting certain sensitive types of websites, adult websites or health websites, whatever they happen to be. Could you end up creating cohorts of sensitive information? Again, the way I understand this has been created is that kind of sensitive cohorts are the functionality with it to prevent sensitive cohorts being created, but that is at least one potential risk with them in theory. So what does that mean in practice? Well, the practical implications, technically it's a big change, but legally is it business as normal? Well, first party cookies will still be permitted. If they're not strictly necessary, then you're still going to need consent for them. FLoCs, even though it's a cohort ID, it still entails some degree of access or storage of information on a device. So again, to access that cohort ID, you're going to need consent. And of course, there are other browsers that may still continue to allow third-party cookies. So long and short of it, if you are a website, you are still going to need to have those cookie consent banners. But it may be that you just need to update them to make sure that the language you're using is broad enough to cover FLoCs and not just refer specifically to cookies. And those cohort IDs, they may still qualify as personal data if you are associating with other data collected from the user device. So, again, things like IP addresses, if you're holding them in conjunction together, collectively, the whole lot will be personal data, and so GDPR compliance will still be required. So that moves us on now to what Apple is doing, and this is in the mobile space as opposed to the kind of the desktop browser space. But just very briefly, in a nutshell, every iPhone has a unique identifier on it, and that identifier is referred to as the ID for advertisers, or IDFA. And in some ways, it can be thought of as being similar to a cookie identifier. If you're using a mobile application, that mobile app, may want to track you for targeted advertising purposes. They can access the IDFA and they can the unique identifier, and again they can use that to track you. Now, the really big change has been that in the latest update to its operating system, iOS 14.5, Apple is now requiring apps to ask for opt-in consent to track. In other words, there's going to be a forced consent to track. There's some limited exemptions for it, where maybe there's access to this kind of data needed for security-related reasons. But long story short, Apple requires opt-in consent. And sorry, just on the previous screen, if I go back here, you will see over on the right-hand side an example of what that consent looks like. Ask app not to track or allow. So the key question I think that's on everybody's lips is the app tracking transparency framework consent dialog sufficient to obtain a GDPR consent? Bear in mind again that GDPR consent has to be freely given, specific, informed, and unambiguous. Specific and informed in particular. When you look at cookie consents on desktop now, they tell you who are the third parties, how are they going to use the data, what purposes are they using it for, and you have they bucket them by category. You have the ability to choose at a category level or an individual provider level whether or not you want to agree to the specific provider or use. The ATTF consent doesn't do that. It just says, are you going to allow for tracking, yes or no? So practically what that's likely to result in is we're going to need a two-stage consent. There will first off need to be the ATTF consent that Apple is forcing developers to have. And then secondly, you will need to have a separate ePrivacy consent window that is to GDPR standards that provides more information specifically about why you are tracking. And an important point to note is that I'm talking about this as though it's just the IDFA, but actually, when you look at the language of the Apple's ATTF, it also includes things like sharing email addresses. So if you're going to share email addresses with data brokers for tracking, again, Apple would say that needs consent. And as yet unanswered question to my mind is, what is the impact of this going to be on free ad-funded apps? Again, if you look here, this is an excerpt on the right-hand side of the screen from the App Store review guidelines. And it basically says that these are what Apple looks at in apps when it's reviewing them to decide whether or not to allow them on the Apple App Store. It says apps should not require users to enable tracking or take other similar actions in order to access functionality, content, or use the app. Very similar to the European Parliament position, but it seems to be saying, if you are a free ad-funded app, you can't force people to agree to tracking in order to access your app, which may mean then that you either have to think about providing non-targeted ads within the app to fund your app that don't rely on tracking information, or potentially you have to provide a paid-for version of your app instead without tracking. So with that, we have about 5 minutes just to answer a few questions. Let's have a look at what's coming in. So a good question here. How would you be able to respond to a DSOL if somebody in a cohort makes a request? Would there be a way to work out how to respond to that individual user without an ID? It's a very good question. So let's say you're an internet company. Somebody submits an access request to you and says, please provide me with all data you hold about me. My cohort ID is 43A7. Well, there is no easy way, just on that alone, you could identify the user because, as as I was explaining in the earlier slides, you could have up to 2,000 users within a single cohort. So, on that information alone, you wouldn't be able to respond. There is Article 11 in the GDPR, which basically says that if you are unable to identify the information relating to a specific individual, then you don't have to fulfill their access rights. And so I imagine what will happen in a context like that is a lot of people will go back and say, well, sorry, we can't identify you just from your cohort ID, so we can't provide you with the information we hold about you. But just be slightly careful, because Article 11 then goes on to say that if the user provides you with other information that enables you to identify them, you may then still have to fulfill the access request. So if the user can say to you, well, here's my cohort ID and here's my IP address, then actually you might be able to look them up depending on the logs you're maintaining. If you've not obfuscated IP addresses, you might then be able to match their IP address with their cohort ID and then go back to them and actually look up their data and provide them. So it's not necessarily a complete get out of jail free card, but it is something that you would need to look at. We had a question here: does the federated learning on the device trigger the application of the ePrivacy Directive? I think this goes back to one of my earlier slides, and I think the short answer to that is yes, that it does, because in order for that federated learning, in other words, in order for the browser to be able to assign you to a cohort, it needs first off to be gathering information about the websites that you're visiting, but importantly, it then needs to be able to kind of assign a cohort ID to your browser. That information will be stored on your device, and so there will be at least some level of storage of information on the device. The bit I'll admit I'm not 100% clear on as well is actually how you segment audiences entirely into different cohorts. You sort of have to imagine that there is some information that's going to be shared back to Google, and if that does include any information being taken from a user's device, then again, that would also trigger ePrivacy related issues. So kind of one way or another, there will almost certainly be an ePrivacy requirement for consent. Quite what that consent covers is maybe a little bit unclear at the moment from the Google initiative, but yes, long story short, there will be a need for consent. I think there's a question here about, there's been some skepticism about the federated learning of cohorts concept and whether it really is effective in preserving people's privacy. And, and sort of asking the question, is this something Google has considered in introducing FLoCs? I think it's a very difficult question to answer, really. I can't pretend that I'm in Google's mindset, but I think the issue of targeted advertising is one that is hard to make go away, because I think everybody recognizes that at the moment there seem to be fundamentally only two models to fund the internet. You either ask people to pay for websites or you serve them some degree of advertising. What studies tend to show is that if you give the people the choice of a free internet or an ad-funded internet, a completely free internet, people will choose the free internet. But if you ask people to pay for stuff, actually a lot of people will then decide they would much rather have advertising and an ad-funded internet than a pay-for internet. So, there are some exceptions to that. Some news websites very successfully introduce paywalls, but the internet in general, a lot of websites depend on advertising. I think what Google is conscious of is that in introducing this FLoC concept, they didn't just want to ban third-party tracking and third-party advertising entirely, because that could have a very serious impact on the ability of websites to fund their content. On the other hand, they recognize that users expect greater privacy, and there's a lot of pressure on from the regulatory community now to provide users with greater standards of privacy as they're browsing around the internet, and that of course is entirely correct and proper. So I think Google is trying to walk that very difficult line between those two things. I won't pass judgment on how successful they've done that. You can form your own views based on what you've heard today. Let's see if we've got time for one last question. Let's see, the EDPB voice assistant guidelines seem to prevent reliance on legitimate interest once consent under the ePrivacy Directive has been obtained. It requires consent under the GDPR to avoid undermining consent obtained under the ePrivacy Directive. Very clever question here. For those of you that have read the EDPB's guidance on voice assistants, we're thinking of things like Alexa and Siri here. what it basically says is that in order to access voice data on one of those type of assistant type devices, you have to get consent under the ePrivacy Directive, and then subsequently any processing of that data ought to be based on consent, because the original data was obtained on the basis of consent under the ePrivacy Directive. I think, again, important things to remember here are that from memory, I haven't looked at the final version of the guidance, but there was actually some suggestion that actually consent might not be needed if it was necessary to provide the specific service that a particular user had requested. But actually, more generally, even if I'm wrong on that, I think it's always important to remember that the EDPB guidance is a regulatory view on what the law should be. It's not actually necessarily what the law is. And ultimately, the only people who can really decide what the law is are the legislators and the courts who rule on interpretation of the law. I think any kind of regulatory guidance we get, of course, does set the agenda in terms of how regulators will look at these issues and therefore how they're likely to enforce them. And so obviously it's an important decision as a business to take, an important issue as a business to take into account how regulators will think about these things. So yeah, jury is a little bit out, but obviously if you're relying on non-consent based grounds, having obtained consent under the ePrivacy Directive, then it probably does increase risk of regulatory enforcement a bit. So with that, I have taken us to the hour. I do thank you, everybody who has stayed with us through to the bitter end. Thank you to Thomas as well for your input on enforcement around the EU. We do hope this is useful. We will be running more webinars throughout the year. We hope you will join us on those. And we will be providing a recording of this webinar in due course as well. So thank you very much to everybody for joining.